Today we're on section 12, which deals with declaratory judgments and opens us up to some questions on nuisance before we finish today, which then opens the door to section 13, which we are going to do on Thursday. And those are interesting and important cases to refamiliarize yourself with because they're quite common occurrences with respect to the practice of law, that people actually sue for them. What they don't sue that often about are declaratory judgments, certainly not in and of itself. But we'll talk about what the rule says and how the cases work. Rule 57 allows a litigant to ask the court to issue a declaration of the parties' rights and responsibilities, but it has to be to a real or threatened controversy. And so it's kind of an interesting procedure, and we're going to see it in the first case. There's a relatively narrow window when you can seek a declaratory judgment. If you wait until the controversy has actually arisen, such that you're charged with a crime if you were threatened with criminal prosecution, or that there's already civil litigation begun, then it's really oftentimes too late to seek a declaratory judgment. I haven't seen it used separately by itself, because oftentimes if the controversy is sufficiently ripe that there's an injury, then oftentimes you would want the court to address it, and that means you would look for damages or an injunction or something else relative to the violation of law. So normally, if you're going to seek a declaratory judgment at all, it would be coupled with other counts in the complaint, and it's much more common that way when one seeks a declaratory judgment. There is a rule that governs the pursuit of a declaratory judgment, and that's under Rule 57. And also, what you should recognize is oftentimes that declaratory judgments go on a faster track than a regular civil litigation, and even faster than generally claims that are seeking, among other things, injunctive relief. Because the argument has to be that you are faced with a real controversy here. There's got to be an actual controversy for the court to issue a declaratory judgment. It is not something where you're just simply curious as to your rights and responsibilities. You feel like the first case here today, that you're between a rock and a hard place, and so that you want to get the court's blessing for what you're doing, or a declaration as to precisely what you're supposed to do under the circumstances where you think there's a breach and the liability could be extensive. So a declaratory judgment is a judgment of the court that determines what the rights and obligations of the parties are to a real or threatened controversy. So, and again, it's a narrow window between when you have a sufficiently real or threatened controversy such that the court will issue a declaratory judgment, and when it's too late, because already now we have not just a threatened controversy, but there's been charges begun in the criminal system, or there's been a piece of civil litigation begun, and at that point then the likelihood of the court getting involved in issuing a declaratory judgment is far less. And we've got additional problems when we talk about the difference between state and federal courts in this regard, or the interplay between federal and state courts, and that gets us into this Anti-Injunction Act, which is also a concern. As a general matter, one court is oftentimes, once a case has begun, one court is generally loath to come in and issue an injunction against that matter from proceeding. There will be occasions where they will do it, and there are occasions where they will have to do it. But it's kind of a difficult sell, especially if that one was first, to get one judge to weigh in on enjoining a party from proceeding in another court. It's part of its respect, part of it's the recognition of states' rights and the federal court's unwillingness as a general matter to get involved in pending state court matters. Go ahead.
Can you please go over the meaning of the injunction? You said it determines what the rights and obligations.
No, the meaning of declaratory judgment, not an injunction, right?
Yeah.
Okay.
Yeah.
It determines what the rights and obligations of the parties are to a real or threatened controversy.
Okay.
Instead of awarding damages, what they're going to do is issue a declaration of the parties' rights. And as we see in the third case today, we do get an injunction there ordering them not to interfere with those rights and requiring them to restore the status quo and the like. So what it does, you know, suppose I told you that if you don't ship me those goods in accordance with the terms of the contract, I'm going to sue you for $10 million. But your argument is, I can't ship those goods. They no longer make them. The product is not available. The raw material is not available. It's impossible to perform in accordance with the contract. That might be a situation where instead of just waiting till you breach and then being a defendant, you might go into court seeking a declaratory judgment saying there is no way we can comply and provide the goods that the contract initially required. The raw material is no longer available, nor is the finished product. It is impossible to comply. Judge, we want you to issue an order that we are under no obligation to try to obtain such goods any longer, and we're not in breach because it's impossible to perform in accordance with the terms of the contract. So you're asking for a declaration of your rights that in essence there is no breach and you won't be in violation if you don't comply. And what it does is it's better than waiting for the breach and then being sued for $10 million and then defending on the same basis. You know, we've seen it before. We see it in the first case today where they tell someone, listen, if you come back here tomorrow, we're going to arrest you because you're a trespasser. Well, you feel like you do have constitutional rights and you want to continue to exercise them. But do you want to exercise them with the threat and the likelihood that you will in fact be arrested, processed through the criminal justice system, and at that point then it's too late to look for a declaratory judgment. Now you still have your constitutional defenses, but you're a defendant, you've been fingerprinted, you may spend some time in jail waiting bail and the like, and then hopefully at the end of the process you will be right about your constitutional rights. But if you're wrong, then you will have a criminal record and perhaps even serve more time in jail. So you have a problem that the court needs to address. And it's not just, hey, I was thinking, this is real, that there's going to be significant repercussions if we move forward. Go ahead.
That wasn't me.
No one said, does that answer your question? No,
Yeah.
It does, right? Mm-hmm. And seriously, it is a traditional equitable remedy, so we've got to address it. But it is very, very rare that I've seen it used, and I've done a ton of different pieces of civil litigation. I think the times where I've seen it used is where it's a count of a multiple count complaint. So you've got 6 counts, and one of them might be seeking a declaration that okay, we don't have any obligation. But really what I'm looking for is damages or an injunction. I'll throw it in as a count. And where you sometimes see it is in the first case, I haven't handled any like that, but where you have threatened criminal prosecution for exercising your constitutional rights, and to the extent you choose to exercise them, you may well face being arrested and then processed through the criminal system. And under those circumstances, that's sort of the classic and appropriate example of using the declaratory judgment, because it makes no sense to have to suffer potentially being convicted of a crime when you believe you're well within your constitutional rights. That's ideally where the declaratory judgment should come in. But again, usually there's not a lot of threats to arrest you. They just generally arrest you, and then you're probably too late at that point. You see it sometimes in the business context that I described to you. You might say, and I'm sure you see it, I haven't seen it, but you'd see it in non-compete agreements. I think especially you'd see it with the new legislation in Massachusetts on non-compete agreements, that in order to be enforceable, the employer would have had to take steps in advance, that you might see someone suing to invalidate a non-compete agreement so that they can continue to work for their new company. I could see it in that, especially where we've had changes in the mass non-compete law. Questions on declaratory judgments? Well, if you look at the first case, it's actually the classic example of when a declaratory judgment would be appropriate and appropriately sought, and it's Steffel versus Thompson. So he is protesting the Vietnam War, and he's at a shopping mall. He's actually on the exterior sidewalk of the shopping mall. And he is told that he can't continue to protest and hand out his leaflets, and that if he comes back tomorrow, he's going to be charged with criminal trespass under Georgia law. So what he does is he brings an action for injunctive relief, requesting that they be enjoined from arresting him because he's exercising his constitutional rights, and he wants a declaration by the court that he does in fact have the right to protest, to give his handbills out as long as he is outside the mall's premises on the public sidewalk. And so the first thing is you've got to ask yourself, do we have what we call this real or threatened controversy? How do we know he's going to be arrested? How do we know that there is a genuine dispute here that the court should weigh in on? And how do we know in this case that that's likely? Because his friend, who was doing the same thing, was arrested the day before. So the fact is that if he's not just saying this is a possibility, if you look at the facts, it's more than a mere possibility, because they arrested his friend, and he's got a legitimate argument, because when this happened the day before, or some short time before this case was filed, the manager of the center called the police, and the petitioner and his companion were again told failure to stop their handbilling would result in the arrest. The plaintiff left to avoid arrest. His companion stayed, and he was arrested and subsequently arraigned on a charge of criminal trespass in violation of Georgia law. So what he's saying is, if I go back, I'm not just thinking I'm going to be arrested. They're going to follow through with their threats, just like they did with my friend. I think I'm well within my constitutional rights to be able to do this, but I'm not willing to risk having a criminal record as a result of this. What I want the court to do is to weigh in on this and issue a declaration of my rights. If I'm wrong, then I likely will make the choice not to go back there. But if I am right and within my constitutional rights, and you have to tell Georgia that they can't be arresting me for doing this. This is the classic declaration of his rights to a real controversy, because a lot of times that becomes kind of a catch-22. How do we show it's sufficiently ripe as a controversy that the court will weigh in, but not overly ripe such that there's an action pending that the court is likely to defer to? Well, this is the best way to prove it. It's just an unusual circumstance where he happened to be there the day before, and his friend was arrested shortly after he left to avoid arrest. So he's got a real or threatened controversy. Now, I would need you to look at the beginning of the decision, because this becomes an important thing to start to think about too. It says, when a state criminal proceeding under a disputed state criminal statute is pending against a federal plaintiff at the time his federal complaint is filed, this is Younger versus Harris, the Anti-Injunction Act, that unless bad faith enforcement or other special circumstances are demonstrated, Principles of equity, comity, and federalism preclude issuance of a federal injunction restraining enforcement of the criminal statute in all but unusual circumstances. This is the whole notion that the federal court has to respect the rights of the state to prosecute actions within its jurisdiction. And once that action is pending, the state has to acknowledge and provide for any constitutional defenses they have. And at the end of the day, as that case works its way up through it, if you don't like it, the result, and at the end of the day you feel that the state court hasn't properly honored your constitutional defenses, at that point maybe the federal court will look at it. But they are not likely to intervene in pending state court matters. That's the Anti-Injunction Act. The act prevents, as a general matter, a federal court from enjoining pending state court matters. As it says here, in all but unusual, extraordinary circumstances, that's going to be the way. So don't think you can just, you don't like what's going on in state court, run over to the federal court to see if they'll issue an injunction against those pending state court actions. You've got to have an extraordinary set of circumstances where they would do that. But absent being able to show bad faith in harassment and the like, the likelihood is the court will not issue an injunction against pending state court matters, but there is no pending state court matters with respect to this plaintiff. With respect to the other plaintiff there is, but he was not arrested because he left there. And so as the court goes through this, there's no doubt that they've got a live controversy and that it is appropriate that the federal court look at the plaintiff's constitutional rights here, recognizing that they won't have problems with the pending state court matter, because there is none, or interfering in a matter that's appropriately reserved for the states and respecting the states' rights to adjudicate controversies there. But there is no pending state court matter here, so that problem doesn't raise its head. The court spends some time actually going through as to why there is no problem under comity or federalism of states' rights, but the simple resolution of that is that there's no pending state court proceedings with respect to this plaintiff. And so at that point then the court can look at whether the declaratory judgment is appropriate and whether his constitutional rights would in fact be impeded by this Georgia statute that prohibits him from exercising those constitutional rights. The court has to now decide whether the declaratory judgment should be appropriate and should be granted, and an injunction issue against Georgia from arresting him with respect to that criminal charge. Once they are able to determine that there is no bar preventing them from looking at the controversy and issuing the declaratory judgment, they likely are going to find that there is no problem with issuing a declaratory judgment with respect to his constitutional rights under the circumstances, because there is no pending state court matter. He does have constitutional rights that would be impeded by his arrest and prosecution under the criminal law if he goes back exercising those constitutional rights. And so under these circumstances, it would be appropriate for the federal court to be able to look at the controversy on its merits and ultimately decide whether to issue, and I think likely, issue the injunction for and order declaratory judgment that he is within his constitutional rights under the circumstances. I want you to look at footnote 19 in the case, because it's just an interesting piece of it that a similar set of circumstances happened regarding Roe versus Wade. because we tend to think that that was the case that's so important, and it was, with respect to abortion rights and the like. But in Roe versus Wade, there was a pending prosecution of Dr. Halford under the Texas abortion law. And so since there was, that was found to render his action for declaratory and injunctive relief impermissible. And the reason is because he had a pending state court matter. But this did not prevent the plaintiff Roe, just like the plaintiff here, against whom no action was pending, to obtain a declaratory judgment that the statute that prohibited Roe's abortion-related activities, that the statute itself was unconstitutional. So we had a similar type of case. Everyone knows the name of Roe versus Wade, but it was Halford who was actually then prosecuted criminally for doing the same types of things, and he could not seek relief in federal court on those constitutional grounds. It says here there's a concurring opinion that talked about, it says that the prosecution under state law should be accorded res judicata effect in any later prosecution of that very same conduct. Under what circumstances can we use res judicata?
Claim preclusion.
That's what it's called. Res judicata is claim preclusion. Under what circumstances can you have claim preclusion?
It's the same kind of claim. When the same kind of claim is being brought by the same parties.
Is that the law? Same kind of claim by the same parties?
It's not the same kind. The same issue, the same matter has been already fed inadequately.
Say what? Say again.
If the same
Same claims.
claim has already been adjudicated and then a firm conclusion has been reached.
It's been adjudicated and what?
And then
Yeah, don't,
and a firm conclusion has
fair
been
conclusion?
Yeah.
Yeah, that sound familiar to you now?
It's a fair, fully final.
There we go. There has to be a full, fair, and final adjudication on the merits of the claim in order to have res judicata, right? Full, fair, and final adjudication on the merits of the claim. And what that does then is it precludes either the same parties, and usually res judicata is the very same parties, or someone in privity with those parties from relitigating those issues, right? Full, fair, and final adjudication on the merits is going to preclude the relitigation of those claims. And there's a related principle about issue preclusion. What's that one called?
Collateral estoppel.
Very good, right? Collateral estoppel. Same basic principle. Full, fair, and final adjudication on the issues is going to be binding on the same parties or anyone in privity with those parties if those issues have been adjudicated fully, fairly, and with finality. So res judicata and collateral estoppel come into play at some point as well. Let me just see. There's another footnote in the concurring opinion at 4 that just talks about the principle that we already said. Federal courts should ordinarily refrain from enjoining ongoing state criminal prosecutions. And I am hopefully stressing to you the notion that it is very, very difficult, once an action is pending somewhere, to get another court to step on that court's proceedings. There will be circumstances where you will have to try and do it, but they better be extraordinary, because normally one court is going to defer, especially if that court was first in time. First in time matters. So there are many situations, though, where they can't fully adjudicate the entire controversy, or the court we're asking to intervene really does have greater authority and should be more appropriately the one resolving it. But you better be prepared to make that extra argument as to why, because as a matter of course, if someone else is handling it, as a general matter, it doesn't make a difference whether it's state to state, federal to state, or federal to federal. Usually they're going to defer to that other court if they were first in time. So be careful with that and recognize you're going to have to set up those unusual circumstances in order to do it. Okay, that's that one. Mitchum versus Book Mart. And Mitchum versus Foster, actually. So it's It is a Florida adult bookstore, and they are being told that the bookstore, what it does, constitutes pornography, and if they continue to display their goods and do this activity, then they will face potential criminal charges and suffer the consequences of whatever that may be in the event that they would be convicted in state court of the various violations that Florida might choose to charge them with. So we've got another Supreme Court opinion, and if we start out with this Federal Anti-Injunction Act, and it says, the Federal Anti-Injunction Statute provides that a federal court may not grant an injunction to stay proceedings in a state court except as expressly authorized by an act of Congress or where necessary in aid of its jurisdiction or to protect or effectuate its judgment. So again, it gets back to this principle: federal court's not going to enjoin pending state court matters, and it shouldn't get involved in them unless, and this shows two exceptions. Where necessary in aid of its jurisdiction, which I'll explain that in a minute, and the second one is, or to protect or effectuate its judgments, which if you think about the second half, that's pretty easy. If the court has already issued a judgment, and it is res judicata, or potentially collateral estoppel, and now someone's decided to go sideways on that and pursue this matter in another court, well, if I need to protect my judgment that was earlier in time, then I have the right to get involved and issue that injunction, no matter where it might be, in another court. So to protect or effectuate its judgments, that should seem, I think, relatively logical as to why that would be appropriate. The first is, it says, or proceed, or where necessary in aid of its jurisdiction. Now, what that, again, as a general matter, is more likely to mean that they were still first in time, or they likely have jurisdiction over all of the various claims and all of the various parties that would be involved in the controversy. So they have both personal and subject matter jurisdiction such that they could conclude the entirety of this litigation. Well, then that might make sense for them to issue an injunction against some little piece off to the side here, even if that was first in time, that one, let's stay that one while we resolve the bulk of the controversy. Makes sense from a standpoint of judicial efficiency and the like to do it that way. And so those are the only two real exceptions, though. So, but that's the language you want to start to think about as to what you're going to have to likely prove in order to get that federal court to do it. Again, it's very, very rare. You know, court is likely going to box your ears if you don't like what's happening, so you run off to another court. We've done it. It's not that we've done it because, well, sometimes we have done it because we didn't like what was happening in this court, but you're not going to get a warm reception on the other end anyway. You better be prepared to figure out how it fits into these very narrow exceptions. Because if you can't, any relief you're seeking is going to be denied, because everyone sees it as an end run, because in part it is an end run, right? So that's the first thing. Now, I want to talk a little bit about the second half of this. It says, the prosecuting attorney of Bay County, Florida, brought a proceeding in a Florida court to close down the appellant's bookstore as a public nuisance. So what's a nuisance? First year torts? You remember a little bit of this? Huh?
An activity or a thing that interferes with a person's enjoyment of his.
So an activity that interferes with an individual's enjoyment of what?
Of some form of rights. I mean,
What, some form of rights? So it's an interference that, it's an interference with someone's enjoyment of their land.
No.
Is that,
Or their privacy.
or their privacy?
Privacy, yeah.
Yeah? That's what you got? Is there a difference, by the way, between public and private nuisance?
yes.
Are there two different things?
Yes.
So what is the difference?
Like if you're staying at a hotel.
Like, I'm looking for a definition. I'm not looking for examples yet. I don't want your Google definition either. Okay, every year when we get to this point, you got to know this stuff, right? You got a big test coming up one of these summers, or one of these falls, depending on when you're taking the bar exam. And so you've got to start to think more often about how these concepts all tie in. And this nuisance, and that's why on Thursday we're going to look at nuisance, and we're going to look at trespass, we're going to look at public and private nuisance. These types of activities and lawsuits happen a lot. So we've got to figure out what constitutes a nuisance, what makes something public or private. So I need you for Thursday to come back and have a better handle on what those definitions are. I'm going to, for now, say, because is it any interference?
Non-trespassory.
Oh, non-trespassory interference?
For a private nuisance.
Is it, when I studied it in law school, I thought there was like there was a modifier of some sort. Reasonable or unreasonable, or is it any? Does it have to be an unreasonable interference?
It should be unreasonable.
Oh, it should be? This is according to the law, according to your law, according to the law. Is it an unreasonable interference?
It should be unreasonable.
My little note says unreasonable interference, well, this says with the public's right, so this is a public nuisance he's being charged with. I have an unreasonable interference with the public's use, the public right common of the interference with a right common to the public. That's what it says, for public nuisance. But then I get down below, interference with the health, safety, peace, comfort, or convenience of the community. Well, that sounds right to you, you're all nodding your heads now, it sounds like a public interference. And so then, I need to know what the private interference would be. I guess it would be an unreasonable interference with
Private use or enjoyment.
use and enjoyment. That sounds like a language that we should have had. You reading your Google version, Ray, or you finally remembering this?
No, I just had to pull my old outline.
Okay, so Ray, Google Ray. Guy, we got to get a handle. Okay, so we've got public and private nuisance. We're going to see this on Thursday, and it's because there's a bunch of different cases there. Those types of problems that we see on Thursday come up a lot. People have a lot of money invested in their houses. People spend a lot of time in their communities. These types of issues, people are willing to spend money to litigate and have litigated them all the time. And you'd be amazed at how often this neighbors will fight or the community will fight. I saw an interesting one the other day, and now I forget which one. It doesn't come right to mind now. But it's going to be another one of these battles about, not in my backyard. We want to keep the potential nuisance out. But at any rate, they're using nuisance in a slightly different capacity here. They want to say that his dirty bookstore, in essence, constitutes a public nuisance. And so what he wants to do is be able to go, and he does, go to federal court to get his injunction. And the problem he has here, though, is this was a civil proceeding with respect to this public nuisance. The prosecuting attorney wants to close down his bookstore as a public nuisance. The state court entered a preliminary order prohibiting continued operation of the bookstore. And so he tried or started to litigate for a while there, but then decided he was going to go to federal court and seek a declaratory judgment and file a suit for damages under 42 U.S.C. 1983, his violation of his civil rights. And he's saying that Florida laws are being unconstitutionally applied by the state to cause him great and irreparable harm. Irreparable harm is always the argument when you're seeking injunctive relief, as you know. or immediate irreparable injury or harm. And so here what we've got is him filing his federal suit subsequent to the first action that was filed. And we know that there's a bunch of proceedings, and I've been preaching it to you. It is rare that a federal court is going to get involved in pending state court matters. And as it says here on page 230, federalism is a national policy forbidding federal courts to stay or enjoin pending state court proceedings except under special circumstances. So again, you've got to start to think about what would those special circumstances be that a federal court might potentially choose to interfere with pending state court actions. The plaintiff wants to argue that 1983, since they are civil rights actions, that if the state is attempting to or interfering with someone's civil rights, that would be an appropriate set of circumstances where the federal court shouldn't just simply defer to the state, but take a hard look at what the plaintiff's saying, and maybe these are the special circumstances where the federal court should in fact think of issuing the injunction against those pending state court proceedings. As he sees it here, the violation of my civil rights is you're taking away my constitutional rights to distribute this literature, art, as he would see it, and to the extent that Florida is allowed to do that, then the state has taken away his civil rights, and the federal court, this would be one of the rare circumstances where we talk about civil rights violations, that it'd be one of the rare circumstances where the federal court could appropriately and moreover should appropriately think of enjoining those pending state court proceedings because they are interfering with someone's constitutional rights. And so the court has to decide whether a Section 1983 action, which is a civil action that the plaintiff would file, whether that is just the type of special action that would warrant the federal court potentially to issue the injunction against those pending state court proceedings, despite that Anti-Injunction Act that we talked about. And the court, as it worked its way through the analysis, decides it is, right? That when one is arguing that the state has violated the individual's civil rights and they are violating by their actions their constitutional rights, that may be that set of special circumstances, and it certainly is here, that set of special circumstances where the federal court should entertain the plaintiff's motion for an injunction against those pending state court matters, and there would be nothing under the circumstances if a 1983 action is pled that would prevent the federal court from issuing that injunction against pending state court proceedings, because these are special matters when we talk about depriving someone of their constitutional rights. The court, despite what I've said, and despite their language with respect to it will be a rare circumstance where the federal court enjoins pending state court matters, this is one where they will in fact, and they do in fact, decide to move forward and issue that injunction. And they can do it. It's a rare set of circumstances nonetheless, but it can be done. My point to you though is be careful, because yes, it's an example of it, but the state court would still have an obligation to have entertain his constitutional defenses. And oftentimes the federal court would defer and allow the state matter to run its course, and then only when they continue to mess it up and they're done with it to at that point step in and reverse it. Here, because he pled the 1983 action, the court feels that they have the ability to stop it while those pending state court matters are still there. You got one more left to do for Rule 57, and that's this Superior Court decision, Francis versus Horowitz. And the reason I gave you this one is, first of all, it's a Massachusetts case on declaratory judgment coupled with the other problems with the case. But the reason I like it as well, though, is that it sets out what the findings of fact and then the conclusions of law actually look like from the trial court. So you'd get an idea as to how you would frame them for the court upon them requesting you to file findings of fact and conclusions of law. So if you look at the way they are written, it really starts us right from the very beginning, right? Look at finding of fact number 1. Who are the plaintiffs, right? The plaintiffs are Stavros Francis and Costas Francis brothers, and they own 20 to 22 LaGrange, which is where part of the problem is. And then it gives you, well, then there's another abutting piece, and then it tells you who the defendant is because he owns the abutting piece. It goes through the really in detail each fact that was proven at trial and needs to be proven in order for the court to issue the judgment. And as you can see there's a lot of findings of fact as to what the court is making as a determination of what happened here and what ultimately then should be done. If you were writing these for the court, you would also add, take a look at 14. It says, in 1988, plaintiffs received an offer of $750,000 for their property, which they rejected. If you had written this for the court as findings of fact, you would have to put a reference to either an exhibit or the trial testimony as to where that fact was proven. So you might put transcript TR, page whatever, right? Or Exhibit H, if there was an exhibit. And so then the court has the ability to look at either the transcript or the exhibit, whichever reference you made, and say, oh, yep, that's where it came in. They don't need to put it here, it's part of the record. But you would be providing that information for the court so it's easier for them to make these findings of fact and conclusions of law. And as you see, the court went through all of these various factual determinations. Again, declaratory judgments and findings of fact and conclusions of law generally are done with respect to non-jury trials. So the court went through all of the facts it found in determining what it ultimately was likely needed to determine factually to be able to issue a judgment as to what happened here. And as you saw, again, we had this interference with the other person's property by tearing down the fire escape, which potentially would render portions of the property unusable, uninhabitable, and seriously diminish the value of the property as well. Also create an extraordinary danger to people who might have been there. And so at the end of the day, after the court made all these factual determinations, they then went to after 69, they went to this section called Conclusions of Law. Now look at the conclusions of law, because they're just really, they're not as separately detailed as your findings of fact, but you would have submitted, look at the first one. You know, in Massachusetts, to prove trespass to property, plaintiffs must show legal possession of property or the right to legal possession and intentional interference with the property without license or justification. And there's a cite. Well, that would have been your proposed conclusion of law, right? And so the court then now adopts it. And then it gets to us about the easement. Plaintiffs have an easement incident to ownership It's in an open, notorious, uninterrupted, and adverse use of a fire escape for at least 20 years as plaintiffs had constituted prescriptive easement. So it's the language on what gives them a prescriptive easement. Now, the court then is tying some of these conclusions to the testimony that was received, and they talk about prescriptive easements and the like. Again, that's the language that the law would provide. If you, it goes into the language about the law provides on an abandonment of the easement and the like. And then as you get to the end of these conclusions of law, talks a little bit about trespass, what that would require, and then it talks about 93A and what you would have to show under the law would constitute those 93A violations. That's just the conclusions of law. This is the information that would be pertinent to the case in adjudicating the plaintiff's claims that you would have provided to the court that they are now incorporating into the decision of the court in ultimate judgment. And so this is a pretty good example of what this is a good example of what the court's findings of fact and conclusions of law would look like. But your proposed ones wouldn't be that much different from this, as you should be able to tell. And then finally, the court issues its judgment at the end of this here. And so they find for the plaintiffs on a number of the different theories with respect to the interference with their property. And also, they issue a declaratory judgment that they have to restore the second means of egress from the property that they destroyed. And then ultimately, they award them attorney's fees and damages as well. So what you've got here is the court's adjudication of a multiple count complaint, one count of which is that declaratory judgment. This is a much more common example of use of a declaratory judgment in a business context than just sort of the standalone declaratory judgment that you saw in the first case, because it's more often coupled with other causes of action that you have. So it's a count of a multiple count one. Because oftentimes a declaratory judgment in and of itself doesn't necessarily bring the matter to a conclusion. Okay, it says I don't have to deliver the widgets, or it says you can't can channel water on my land. But there still may be other litigation. We would argue res judicata and collateral estoppel and the like, but this doesn't mean that there won't be more litigation. When it's coupled like this, at the end of the day, we're going to resolve the entire controversy. Much more common that you see it as a count of a multiple count complaint. Questions on declaratory judgments? I hope for this section 13, look at these cases carefully, and hopefully you're going to come back to me and have better definitions of both trespass and nuisance and public and private nuisance. And I want you to think about it in the context of these cases, because it's an area that is often litigated, and the valuations are different, and as to how we're going to remedy them depends, at least in part, on what the interference is as well. Okay? I'll see you next time.